operation of law reduced counts 4 and 5 to fifth-degree felonies, and would have no additional finding there. And so therefore the verdict forms have been amended to read that instead of as charged in the indictment, and then the additional finding, it will now read that each of those would be a fifth-degree felony without any additional finding. And I assume you're all right with that, Ms. Mesman?
Yes, Your Honor.
Okay. All right. So I did delete those portions of the jury instruction on counts 4 and 5 that related to additional finding of bulk amount. Okay, and Dan, this goes in the record, the stipulations. It doesn't go to the jury. I forgot to give it to you yesterday. I have to put that on the record. Anything else before we bring in the jury?
No, Your Honor.
All right, if you would bring in the jury, Mr. String. Go ahead and be seated. Go ahead and be seated, folks. All right, good morning, ladies and gentlemen. Again, I'll remind everybody to make sure your cell phones or other electronic devices are turned off. After we adjourned yesterday, we dealt with a number of legal issues. The state rested. The defense is elected not to present any evidence. And so I had to deal with a couple other legal matters regarding the instructions this morning, and we're now ready to proceed. Ladies and gentlemen, you've heard the evidence. It's the duty of the court to instruct you on the matters of law. Court and jury have separate functions. You decide the disputed facts, and the court provides the instructions of law. Now, ladies and gentlemen, it's your sworn duty to accept these instructions and apply the law as it is given to you. You're not permitted to change the law or to apply your own conception of what you think the law should be. All criminal cases begin with the filing of an indictment. The indictment informs the defendant that he or she has been charged with an offense. The fact it was filed may not be considered for any other purpose. Now, the defendant entered plea of not guilty to the charges, which is a denial of the charges, and puts into issue all the essential elements of each offense. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of any one or more of the offenses that have been charged in the indictment. A reasonable doubt is present when, after you have carefully compared all of the evidence, you cannot say that you're firmly convinced of the truth of the charge. It's a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending upon moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Now, ladies and gentlemen, you're the sole judges of the facts, the credibility of the witnesses that were presented, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witness. You'll apply the tests of truthfulness that you apply in your daily lives. These tests include the appearance of each witness upon the stand and manner of testifying, the reasonableness of their testimony, the opportunity they had to see, hear, and know the things concerning which they testified, their accuracy of memory, their frankness, their lack of it, their intelligence, their interest and bias, if any, together with all of the facts and circumstances surrounding the testimony. Applying these tests, you'll assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because that witness was placed under oath. You may believe or disbelieve all or any part of the testimony. You will determine what testimony is worthy of belief and what testimony is not worthy of belief. Each witness was subject to direct examination by the party who called them and to cross-examination by the opposite party. Now, during the trial, counsel was able to inquire into some matters that did not directly relate to issues before the court. Such questions and answers are permitted for the purpose of helping you to determine the credibility and the weight to be given to the testimony and for no other purpose. When a certain witness testified, evidence of prior convictions was introduced to attack the credibility of the witness. You may consider the prior criminal convictions of any witness when assessing that witness's credibility. It is not necessary that the defendant take the stand in his own defense. He has a constitutional right not to testify. The fact that the defendant did not testify must not be considered for any purpose. Now, you've heard testimony from Cassie Brigner, another person who pleaded guilty to some of the crimes charged in this case against the defendant, and is said to be an accomplice. An accomplice is one who purposely or knowingly assists or joins another in the commission of a crime. Whether Cassie Brigner was an accomplice and the weight to be given to her testimony are matters for you to determine from all the facts and circumstances. The testimony of an accomplice does not become inadmissible because of his or her complicity, moral turpitude, or self-interest, but the admitted or claimed complicity of a witness may affect his or her credibility and make his or her testimony subject to grave suspicion and require that it be weighed with great caution. It is for you as jurors, in the light of all the facts presented to you and from the witness stand, to evaluate such testimony and determine its quality and worth or its lack of quality and worth. Now, generally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is presented or is admitted for whatever assistance it may provide to help you arrive at a just verdict. However, as with other witnesses, upon you alone rests the duty of deciding what weight should be given to the experts. In determining its weight, you may take into consideration his or her skill, experience, knowledge, veracity, familiarity with the facts of the case, and the usual rules for testing credibility and determining the weight to be given to testimony. Now, ladies and gentlemen, evidence is all of the testimony that was received from the witnesses and any exhibits that the court has admitted into evidence during the trial. I believe there's 188. Evidence may be direct or may be circumstantial, or it may be both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which they testify. It includes, of course, the exhibits that are admitted into trial, or into evidence during the trial. Circumstantial evidence is proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. To infer or to make an inference is to reach a reasonable conclusion or deduction of facts from which you may, but are not required to make, from the other facts which you have found have been established by direct evidence. Whether an inference is made rests entirely with you. When considering circumstantial evidence, you may not draw one inference from another inference, but you may draw more than one inference from the same facts or circumstances. So in other words, you cannot stack one inference upon another inference to reach a factual conclusion. If circumstances create inferences that are consistent with either acquittal or guilt, the defendant must be acquitted unless the inference in favor of guilt rise to the level of proof beyond a reasonable doubt. In the absence of direct evidence of a person's guilt, circumstantial evidence by itself may justify a finding of guilty if the circumstances are entirely consistent with defendant's guilt, are wholly inconsistent with any reasonable theory that he is not guilty, and are so convincing as to exclude a reasonable doubt of guilt. When the evidence is both direct and circumstantial, you must decide whether the combination of the two types of evidence overcomes the presumption of innocence and convinces you beyond a reasonable doubt that a defendant is guilty. Now, the evidence does not include the indictment, the opening statements, or the closing arguments of counsel that you'll hear in a short while. The opening statements and closing arguments, as the court has indicated previously, are designed to assist you, but they are not evidence. Any statements that have been stricken by the court or that you were told to disregard are not evidence and must be treated as though you never heard them. You must not speculate why the court sustained any objection to any question or what the answer to that question might have been. You must not draw any inference or speculate on the truth of any suggestion that might be included in a question that was not answered. A number of exhibits have been introduced, and testimony relating to them has been introduced and admitted into evidence, and you may consider whether those exhibits are the same objects in the same conditions they were originally. You'll determine what weight, if any, the exhibit should receive in light of all the evidence. Now, although there are 12 counts here, we have a specification in count 12, and then the other 11 counts, there are 2 counts of receiving stolen property, and then the others are aggravated possession, or aggravated trafficking, or possession or aggravated possession. And so the elements are similar, but I'm going to go ahead and I'll define one of each totally in these instructions, and then when I go through the others, I'll tell you that the same definitions apply, and that will speed this up a little bit. And also, just so you know, it's important that you listen to me when I give these instructions, but I am going to give you a written copy of the instructions for your deliberations, so you'll be able to refer to those. Although I will have to make a few changes and typos you've seen me making here, where I need to make some changes. So we'll start with count 1. The law under which I forgot, and engaging in pattern of corrupt activity. So we have the engaging in corrupt activity, trafficking, possession, and receiving. Those are the type of charges we have. So the first count is the defendant is charged in count 1 is entitled engaging in a pattern of corrupt activity. And it is numbered Revised Code Section 2923.32A1. And this law states in pertinent part as follows. No person employed by or associated with any enterprise shall conduct or participate in, directly or indirectly, the affairs of the enterprise through a pattern of corrupt activity. So before you can find the defendant guilty of engaging in a pattern of corrupt activity, you must find beyond reasonable doubt that on or about the period of January 1, 2019, continuing through January 1, 2023, in Highland County, Ohio, defendant, while being employed by or associated with any enterprise, did conduct, participate in, directly or indirectly, the affairs of the enterprise through a pattern of corrupt activity. So each offense will have essential elements that must be proven. The essential elements of the offense of engaging in a pattern of corrupt activity as charged in count 1 of the indictment are as follows. That defendant did, 1, while employed by or associated with an enterprise, 2, conduct, participate in, directly or indirectly, the affairs of the enterprise, 3, through a pattern of corrupt activity, and 4, the offense occurred in Highland County on or about the period within the dates alleged in the indictment. Now, with regard to the element of time, it is not necessary that the state prove the offense was committed on the exact date as charged in the indictment. It's sufficient to prove that the offense took place on a date reasonably near the date claimed, and that definition will apply to all 11 counts, or all 12 counts, I should say. Then, before you can decide whether the state of Ohio has proved beyond reasonable doubt all the essential elements of the offense with which he is charged, you must first decide whether this is the correct county in which this trial should be held. The state must prove beyond reasonable doubt that all or any part of the offense charged was committed in Highland County, Ohio. Now, enterprise. The term enterprise includes any individual, sole proprietorship, partnership, limited partnership, corporation, trust, union, government agency, or other legal entity, or any organization, association, or group of persons associated in fact, although not a legal entity. Enterprise also includes illicit or unlawful, as well as licit or lawful enterprises. Conduct means to direct. Participate means take part in. It is not limited to those who have directed the pattern of corrupt activity. Participate encompasses those who have performed activities necessary or helpful to the operation of the enterprise, whether directly or indirectly, without an element of control. Now, the term corrupt activity means engaging in, attempting to engage in, conspiring to engage in, or soliciting, coercing, or intimidating another person to engage in any of the following conduct. Conduct that constitutes a violation of the following offenses. Count 2, aggravated trafficking of methamphetamine, in violation of RC 2925.03A2, or count 3, aggravated possession of methamphetamine in violation of RC 2925.11. Count 4, aggravated trafficking in drugs in violation of RC 2925.03A2. Or count 5, aggravated possession of drugs in violation of RC 2925.11. Count 7, receiving stolen property in violation of RC 2913.51. when the total proceeds of those combination of violations or value of the contraband or other property illegally sold or possessed in the combination of violations exceeds $1,000. So for purposes of count one, the other counts that are not named there are not to be considered. Now, the total value of all violations, before you can find the defendant engaged in corrupt activity, you must find that the state proved beyond reasonable doubt the defendant is guilty of at least two of the offenses alleged in counts two or three, counts 4 or 5, and count 7 of the indictment, and that the total of the proceeds or value of the controlled substances illegally sold or possessed and the property illegally possessed in all the counts of which you have found the defendant guilty exceeds $1,000. For purposes of this element, ladies and gentlemen, the offense of aggravated trafficking of methamphetamine in count 2 and the offense of aggravated possession of methamphetamine in charge of count 3 are alternative counts related to one incident. Likewise, the aggravated trafficking in drugs charged in count 4 and the offense of aggravated possession of drugs charged in count 5 are alternative counts related to one incident. Therefore, if you find the defendant guilty of counts 2 and 3 and counts 4 and 5, you will consider only the value of the controlled substance involved in those counts once. So in other words, the value from counts 2, 3, one value from counts 2, 3, and one value from counts 4, 5, if your verdicts are guilty of each of those offenses. Now, the term pattern of corrupt activity means one or more incidents of corrupt activity that are related to the affairs of the same enterprise, are not isolated, and are not so closely related to each other, connected in time and place, that they constitute a single event. A finding of pattern of corrupt activity requires proof of at least 2 incidents of corrupt activity by defendant within 6 years of each other. For purpose of this element, the offense of aggravated trafficking of methamphetamine charged in count 2 and the offense of aggravated possession of methamphetamine charged in count 3 are alternative counts, not cumulative, and considered to be one incident. Likewise, the offense of aggravated trafficking of drugs charged in count 4 and the offense of aggravated possession of drugs charged in count 5 in the indictment are alternative counts and considered to be one incident. Now, if you find the state proved defendant guilty by proof beyond a reasonable doubt of 2 or more of the violations alleged in counts 2, 3, 4, 5, and 7 that occurred on different dates as alleged in the indictments, those findings alone are not are insufficient to establish a pattern of corrupt activity. The state must prove beyond a reasonable doubt that at least one of the violations was related to the affairs of the same enterprise alleged and not so closely related to any other act of corrupt activity connected in time and place that they constitute one event. Now, if you find that the state proved beyond a reasonable doubt all the essential elements of the offense charged in count 1, your verdict must be guilty as to such offense according to your findings. If you find the state failed to prove beyond a reasonable doubt that any one of the essential elements of the offense charged in count 2, count 1, of the indictment, your verdict must be not guilty as to such offense according to your findings. Now, the law in count 2 is entitled Trafficking in Methamphetamine, aggravated trafficking of methamphetamine, I believe. Yes, aggravated trafficking in methamphetamine, and is numbered Revised Code Section 2925.03A2. Now, this law states in pertinent part as follows: no person shall knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute a controlled substance when the offender knows or has reasonable cause to believe the controlled substance is intended for sale or resale by the offender or another person. So before you can find the defendant guilty, you must find beyond reasonable doubt that on or about the 12th day of July, 2022 in Highland County, Ohio, the defendant did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute methamphetamine, a Schedule II controlled substance, when defendant knew or had reasonable cause to believe that the controlled substance was intended for sale or resale by the offender or another. The essential elements of the crime of trafficking in drugs, as charged in count 2 of the indictment, are as follows: the defendant did 1, knowingly; 2, prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute; 3, methamphetamine, Schedule II controlled substance; 4, knowing or having reasonable cause to believe it was intended for sale or resale by the defendant or another; and 5, that the offense occurred in Highland County on or about the date alleged in the indictment. The same instruction that definition I gave you about time of the offense and the venue where it was committed apply here. Now, various chemical compounds subject to government control or called controlled substances are placed into various categories or scheduled by the Ohio Revised Code. Methamphetamine is a Schedule II controlled substance. In deciding whether the defendant had reasonable cause to believe that the defendant or another person intended to sell or resell heroin, you must put yourself in the position of this defendant with his knowledge or lack of knowledge and under the circumstances and conditions that surrounded him at that time. You must consider the conduct of the persons involved and decide if their acts and words and all surrounding circumstances would have caused a person of ordinary prudence and care to believe the defendant or another person intended to sell or resell the methamphetamine. Now, a person acts intentionally when he has a purpose or conscious objective to produce a specific result. A person intends an act when it is done purposely and not accidentally. The intent with which a person does an act is known only to himself unless he expresses it to others or indicates it by his conduct. Sale includes delivery, barter, exchange, transfer or gift, or offer thereof. In each such transaction made by any person, whether as a principal, proprietor, agent, servant, or employee. So if you find the state proved beyond a reasonable doubt all essential elements of the offense charged in count 2 of the indictment, your verdict must be guilty as of such offense according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense charged in count 2 of the indictment, your verdict must be not guilty according to your findings. Now, as to count 2, there will be, if there is a finding of guilty, you will then make an additional finding as to the amount of the methamphetamine that was involved. And you will determine whether that amount involved was one of 4 ranges. Less than bulk amount, equal to or exceeding bulk amount but less than 5 times bulk amount, equal to or exceeding 5 times bulk amount but less than 50 times bulk amount, or 4, equal to or exceeding 50 times bulk amount but less than 100 times the bulk amount. If your finding is not guilty, you'll not make any finding on that issue. Under Ohio Revised Code 2925.01, bulk amount of methamphetamine is 3 grams. Now, the law with which the defendant is charged in count 3 is entitled aggravated possession of methamphetamine and is numbered Revised Code section 2925.11a. This law states in pertinent part as follows: no person shall knowingly obtain, possess, or use a controlled substance. Before you can find the defendant guilty of aggravated possession of methamphetamine, you must find beyond a reasonable doubt that on or about January 12, 2022 in Highland County, Ohio, the defendant did knowingly obtain, possess, or use methamphetamine, a Schedule II controlled substance. So the essential elements of the crime of aggravated possession of methamphetamine as charged in count 3 of the indictment are as follows. The defendant did 1, knowingly; 2, obtain, possess, or use; 3, methamphetamine, a Schedule II controlled substance; and 4, the offense occurred in Highland County on or about the date alleged in the indictment. So the instruction I gave you about time and venue also apply here. Now, a person acts knowingly regardless, the definition of knowing. A person acts knowingly regardless of his purpose when he is aware his act will probably cause a certain result, or he is aware his conduct will probably be of a certain nature. A person has knowledge of circumstances when he is aware such circumstances probably exist. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from those facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that the defendant's actions will cause a certain result or be of a certain nature. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose or knowledge. Where an act is a crime, a good motive or purpose is not a defense. Possession of a controlled substance is an essential element of the offense of possession as charged. Possess or possession means having control over a thing or substance, but may not be inferred solely from mere access to the thing or substance through ownership or occupation of the premises on which the thing or substance is found. Possession is a voluntary act if the possessor knowingly procured or received the chemical or was aware of his control thereof for a sufficient period of time to have ended his possession. A person has possession when he knows that he has the object on or about his person or places it where it is accessible to his use and direction, and he has the ability to direct or control its use. Two or more persons may have possession if together they have the ability to control it, exclusive of others. Ownership is not necessary. A person may possess or control property belonging to another. And controlled substances, I've already instructed you, methamphetamine is a Schedule II controlled substance. So if you find beyond a reasonable doubt all the essential elements of the offense charged in count 3 of the indictment, your verdict must be guilty as to such offense according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of count 3 of the indictment, your verdict must be not guilty as to such offense or according to your findings. And with count 3, if you determine that the state has proven that offense beyond a reasonable doubt, then you would also make the additional finding as to the amount, as I've already instructed you in count 2. And bulk amount is the same for methamphetamine, 3 grams. Now, count 4, the law under which the defendant is charged in count 4 is also entitled aggravated trafficking in drugs and is numbered Revised Code 2925.03A2. This law states in pertinent part, no person shall knowingly prepare for ship, transport, deliver, prepare for distribution or distribute a controlled substance when the offender knows or has reasonable cause to believe controlled substance intended for sale or resale by the offender or another. So that's the same definition as to the second count. And so before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 12th day of July 2022 in Highland County, Ohio, the defendant did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution or distribute hydroxyphencyclidine, or PCP, a Schedule II controlled substance, when the defendant knew or had reasonable cause to believe this substance was intended for sale or resale by the offender or another. So the essential elements of that offense in count 2 are the same as count 4 are the same as count 2, except the substance alleged to be involved, rather being methamphetamine, is hydroxyphencyclidine. But otherwise, the elements are the same. And so the definition I gave you as to count 2 and as to time, venue, apply. As well as the definition of knowingly and motive applies in this count as well as it does in count 2, and how you determine that. And again, hydroxyphencyclidine is a Schedule II controlled substance under the Ohio Revised Code. The definition of the words prepare, shipment, ship, deliver, distribution, and distribute have the same meaning as you understand them in your normal experience. That also applies in count 2. Reasonable cause to believe is the same definition that I gave you in count 2, as well as the definition of intent is the same. Sale, definition of sale, an offer is the same. So if you find beyond the state proved beyond a reasonable doubt all the essential elements of the offense charged in count 4 of the indictment, your verdict must be guilty as to such offense according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense charged in count 4 of the indictment, your verdict must be not guilty as to such offense according to your findings. All right, now, the law under which the defendant is charged in count 5 is entitled aggravated possession of drugs and is also entitled Revised Code Section 2925.11a, just like count 3. The count 3 then, before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about November 9, 2020, oops, that's the wrong date, it would be July 12, 2022, in Highland County, Ohio, the defendant did knowingly obtain, possess, or use hydroxyphencyclidine, a Schedule II controlled substance. The essential elements of the crime of aggravated possession of drugs then in the charge of count 5 are the same as in 3. The defendant did knowingly obtain, possess, or use hydroxyphencyclidine, and the offense occurred in Highland County, Ohio on or about the time alleged. So the definitions that I gave you earlier as to count 3 and the other indictments or counts, time and venue apply. The same definition of knowingly, how you determine it, motive, possess, controlled substance are all the same. Find that the state proved beyond a reasonable doubt all the essential elements of the offense charged in count 5 of the indictment, your verdict must be guilty as to such offense according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense charged in count 5 of the indictment, your verdict must be not guilty as to such offense according to your findings. Now, count 6, the law under which the defendant is charged in count 6 is entitled possession of cocaine. And it's numbered in Revised Code Section 2925.11a. And this law states in pertinent part, no person shall knowingly obtain, possess, or use a controlled substance. So before you can find defendant guilty of possession of cocaine, you must find beyond a reasonable doubt and on or about July 12, 2022 in Highland County, Ohio, this defendant did knowingly obtain, possess, or use cocaine, a Schedule II controlled substance. The essential elements of that are the same as count 3 of 5. The defendant did knowingly obtain, possess, or use cocaine, a Schedule II controlled substance. The offense occurred in Highland County on or about the date alleged in the indictment. So the definitions to all those terms that apply to the previous possession charge and count 3 and 5 also apply here. Time, venue, knowingly, how you determine it, motive, possession, controlled substance. And your findings is if you find beyond a reasonable doubt, state proved beyond a reasonable doubt all the essential elements of the offense charged in count 6, your verdict must be guilty as to such offense according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense charged in count 6 of the indictment, your verdict must be not guilty as to such offense according to your findings. Now, the law under which the defendant is charged in counts 7 and 8 is entitled receiving stolen property, is numbered High Revised Code Section 2913.51a. This law states in pertinent part as follows: no person shall receive, retain, or dispose of property of another, knowing or having reasonable cause to believe that property has been obtained through commission of a theft offense. The defendant is charged in counts 7 and 8 with receiving stolen property. Before you can find defendant guilty of count 7 or 8, you must find beyond a reasonable doubt that on or about the 12th day of July 2022 in Highland County, Ohio, defendant received, retained, or disposed of property of the owner specified in each count, knowing or having reasonable cause to believe the property had been obtained through the commission of a theft offense. So the essential elements of counts 7 and 8, the charge of receiving stolen property, are that the defendant did 1, receive, retain, or dispose of property of another. Count 7, that would be Bill Bird. Count 8 would be Robert Guyton. 2, knowing or having reasonable cause to believe property had been obtained through commission of theft offense. And 3, that the offense occurred in Highland County on or about the date alleged. So again, the definitions I've given you previously on time, venue, knowingly, how you determine that, motive is all the same in this count, in these two counts. Property means any property, real or personal, tangible or intangible, and any interest or license in that property. Reasonable cause to believe is the same definition, but has a little bit different since it's a theft or receiver's charge, so I'll read it. In deciding whether the defendant had reasonable cause to believe the property had been obtained through the commission of a theft offense, you must put yourself in the position of the defendant with his knowledge or lack of knowledge and under the circumstances and conditions that surrounded him at the time. You must consider the conduct of the person involved and decide if their acts and words and all the surrounding circumstances would have caused a person of ordinary prudence and care to believe that the property had been obtained through the commission of a theft offense. Now, theft offense means any of the following: any violation of Section 2913.02 of the High Revised Code, which is entitled theft, and or 2913.51 of the High Revised Code, which is entitled receiving stolen property. Now, if your verdict is guilty as to count 7, then you will decide whether the state proved beyond a reasonable doubt that the property involved was a motor vehicle, as defined in Section 4501.01b of the High Revised Code. Section 4501b of the High Revised Code reads in pertinent part, motor vehicle means any vehicle, including mobile homes and recreational vehicles, that's propelled or drawn by any power other than muscular power or power collected from overhead electric trolley wires. Your verdict's not guilty, you'll not consider that issue. Count 9 is entitled aggravated possession of methamphetamine. Basically the same as count 3, except it's a different date and a different amount. But the same definition applies and the same requirements apply. that you must, before you can find him guilty of aggravated possession of methamphetamine, you must find beyond reasonable doubt that on or about September 6, 2022 in Highland County, Ohio, defendant did knowingly obtain, possess, or use methamphetamine, a Schedule II controlled substance. The elements of that offense are the same as I've already explained to you. The definitions that apply in the other, in the counts 3 and 5 and 6 apply: time, venue, knowingly, how you determine it, motive, possession, controlled substance. So if you find the state proved beyond reasonable doubt all the essential elements of the offense charged in count 9 of the indictment, your verdict must be guilty as to such offense according to your findings. If you find the state failed to prove beyond reasonable doubt any one of the essential elements of count 9 of the indictment, your verdict must be not guilty as to such offense according to your findings. Okay, the law on count 10 is under the same section, 2925.11a, as the other possession charges. It's entitled aggravated possession of a fentanyl-related compound, and reads in part, pertinent part, no person shall knowingly obtain, possess, or use a controlled substance. So before you can find the defendant guilty of possession of a fentanyl-related compound, you must find beyond a reasonable doubt that on or about September 6, 2022 in Highland County, Ohio, defendant knowingly obtain, possess, or use a fentanyl-related compound, a Schedule II controlled substance. So again, the elements of the offense are the same as I just instructed you in count 9 and all the possession charges. And so the same definitions of time, venue, knowingly, how you determine it, motive, possession, controlled substance definition are all the same. So if you find the state proved beyond a reasonable doubt all the essential elements of the offense charged in count 10 of the indictment, your verdict must be guilty as to such offense according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of count 10 of the indictment, your verdict must be not guilty as to such offense according to your findings. Now, the law under which the defendant is charged in count 11 is entitled possession of cocaine and is numbered Revised Code 2925.11a. This law states in pertinent part as follows. Again, the same, but no person shall knowingly obtain, possess, or use a controlled substance. Before you can find the defendant guilty of possession of cocaine, you must find beyond reasonable doubt that on or about September 6, 2022 in Highland County, Ohio, defendant did knowingly obtain, possess, or use cocaine, a Schedule II controlled substance. So the essential elements of that offense are the same as the other, except the offense is the substance involved is alleged to be a fentanyl-related cocaine in this case. Let's see, wait a minute. Count 10 is, fentanyl-related compound was count 10, and count 11 is possession of cocaine. All right, so the same definitions apply: time, venue, knowingly, how you determine it, motive, possession, controlled substance, and cocaine is a Schedule II controlled substance. So if you find the defendant proved, or if you find that the state proved beyond a reasonable doubt all the essential elements of the offense charged in count 11 of the indictment, your verdict must be guilty as to such offense according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense charged in count 11 of the indictment, your verdict must be not guilty as to such offense according to your findings. Okay, count 12. Count 12. If you find defendant guilty of count 1 of the indictment, you will deliberate make a finding as to whether any of the items set forth in count 12 are subject to forfeiture. There are 54 items that are listed, and they'll be listed on the verdict form. It includes a number of personal property items, includes cash, includes real estate, and so forth. But those are identified for you. The state claims the defendant's right, title, and interest in 54 items is subject to forfeiture. It alleges the items were derived from, directly or indirectly, or realized through conduct in violation of the first count of the indictment, only the first count of the indictment. The burden of proof on the state with regard to forfeiture is by a preponderance of the evidence, not beyond a reasonable doubt, which is the burden that the state must prove the defendant is guilty of the offense of engaging in a pattern of corrupt activity in count 1 of the indictment. Now, preponderance of the evidence is the greater weight of the evidence. That's the evidence that you believe because it outweighs or overbalances in your minds the evidence opposed to it. Preponderance means evidence that's more probable, more persuasive, or of greater probative value. It is the quality of the evidence that must be weighed. Quality may or may not be identical with quantity or the greater number of witnesses. In determining whether or not the items of property specified in count 2 are subject to forfeiture has been proven by preponderance of the evidence, you should consider all the evidence bearing upon that issue regardless of who produced it. You must make a finding as to each of those items, and if the weight of the evidence is equally balanced, or if you're unable to determine which of the parties has preponderance as to each item, then the state has not proven that property is subject to forfeiture. Now, if you find beyond that the state proved beyond a reasonable doubt any or all of the essential elements of any one or more of the offenses charged in the separate counts of the indictment, your verdict must be guilty as to such offense or offenses according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of any one or more of the offenses charged in the separate counts of the indictment, your verdict must be not guilty as to such offense or offenses according to your findings. The charges set forth in each count constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count of the indictment and each separately, and you must state your findings as to each count uninfluenced by your verdict as to the other counts. Defendant may be found guilty or not guilty of any one or all of the offenses charged against defendant in the various counts of the indictment. All right, so that's a pretty lengthy description or instruction, and again, I will make some corrections here to make sure that you have everything here that you need correct, and you'll be able to use that if you need to during your deliberations. Now, at this time, we're going to hear closing arguments of the attorneys. Now, just like opening statements, closing arguments are not evidence. They're simply the view of each side as to what they believe the evidence is and what they believe that is shown, but it's not evidence. The state of Ohio has the burden of going forward, or of proof of the case, and so they have the right to argue first, and then after the defendant presents his closing argument, the state may offer a rebuttal argument. So at this time, Mrs. Collins, on behalf of the state.
Yes, thank you. May it please the court, Ms. Memsick, ladies and gentlemen of the jury, I first want to thank you for your time and attention to this very complicated and detailed case. We are one of the few countries that uses a jury system to decide guilt, and that only works with citizens like yourselves who take your service seriously, and for that I want to thank you. Now, as the judge said, I have 2 opportunities to address you in closing, and you've heard a lot of stuff already, so I'll keep the first one short and to the point. In June of 2022, investigators Randy Sanders and Chris Bowen met with the CI and made the first of 2 undercover drug buys from this defendant, known to them as Scoots Johnson. Following that second undercover buy, the task force in the sheriff's office and the Greenfield Police Department worked together in serving a search warrant at 12385 Butters Road in Highland County, the property owned by this defendant. Both drug buys were made from this property, and the search warrant was granted. During that search on July the 12th of 2022, officers located over 200 grams of methamphetamine. They located PCP, or hydrochlorozine, in multiple bags and almost 4 grams of cocaine. This is more than would be used for personal use. These drugs were intended to be resold because that is how the defendant operated his business. He bought drugs cheap and resold them at a profit. He also traded drugs for stolen items and for guns. Both stolen items and drugs were recovered during the search warrant, as well as guns. Also recovered were all the items necessary to operate a drug business: bags to resell in, scales to weigh, and books to keep track of the money coming in and out. But being busted once didn't stop this defendant from continuing his drug trade, and on September the 6th of 22, he was again arrested, this time for having no driver's license. The resulting search of the vehicle found more drugs, more baggies, more scales, and more ledger books. You now know that when this defendant and Cassie Brigner were arrested on September 6th of 22, they were heading to get their belongings from the Butters Road property, and then they were going on the run because they thought indictments were coming out that day. And despite paying Travis Gibson in some scam to get their charges dismissed, they were afraid of being indicted. Ladies and gentlemen, there is no question that this defendant worked with Cassie Brigner and others to supply a large quantity of methamphetamine to Highland County. You can see this from the ledger books and from the amount of drugs that was recovered. Johnson is guilty of trafficking or selling methamphetamine. He is guilty of trafficking or selling PCP, and he is guilty of possessing cocaine. He is guilty of possessing a stolen pickup truck and stolen tools. He is guilty of possessing fentanyl-related compound, cocaine, and methamphetamine in the traffic stop on September 6th of 22. And because Johnson did all of this to further his criminal enterprise, he is guilty of engaging in a pattern of corrupt activity. Because he traded items for drugs and used his property to house drugs, sell drugs. He used guns to trade for drugs and to protect his drugs. He should not retain ownership of that property, and it should be forfeited pursuant to the forfeiture specification. Thank you.
All right, Ms. Memsick, on behalf of the defendant.
Your Honor, may we approach?
May. All right, May, proceed.
Thank you, Your Honor. May it please the court, Ms. Collins, Mr. King. Ladies and gentlemen, I want to thank you as well. I think everyone in this courtroom feels very fortunate that we've had such an attentive jury. You've heard the state's narrative, and you know what they want you to believe. They want you to believe that Richard was the leader of a drug enterprise, that he amassed this incredible amount of guns and property that was stolen. In reality, he's a guy who liked firearms, which isn't against the law, who got involved with a very cute young girl who had a very serious drug habit. It's interesting that Richard was never found with drugs on him. The only evidence of him selling drugs came from a confidential informant that you didn't hear from. So I want to go through the order of the witnesses and ask, what did you really learn yesterday? Beth Underwood testified that drugs are drugs. She has a role in a laboratory and she was able to identify certain things, but she can't tell you where they came from. She can't tell you anything else about them. Mr. Bird told you that he doesn't know who stole his truck. Mr. Guyton told you that he doesn't know who stole his chainsaw. There was no testimony presented to you that Mr. Johnson knew these items were stolen. None. So please hold the state to their burden. All that's been presented is that these items were stolen, they were recovered on a large piece of property, and you heard Investigator Sanders refer to this as a compound. Deputy Quenneville told you that he recovered items on September 6th from a car with 2 people in it. Sergeant Seagram told you that Richard was arrested during the execution of a search warrant in July, and when that happened, he had no contraband on him. Mr. Bowen's testimony provided more information, but again, that's where I want you to look at what you didn't hear. He testified that the CI's videos were live and recorded with audio, and you didn't see or hear any of those. There was no testimony that Richard was even on these videos conducting a buy, because he wasn't. On the first video, he admitted that Cassie is the only one that he can see. And he testified that he doesn't know who painted that truck, but the state wants you to make assumptions. Detective Sergeant Antonor didn't want to answer any of my questions directly. He had a long-winded explanation for everything, mostly yes or no questions. He did admit there were multiple people on that property, just like Mr. Bowen, multiple people present at the time of the alleged buys, and that there was no further investigation into any of those people, because that wouldn't fit the narrative that Richard and Cassie were running the show. He and Investigator Sanders highlighted that Richard wasn't working, but they did admit they were generally aware he was receiving Social Security. He had an income. There are no identified owners, other owners, for the majority of these alleged stolen items, and this is an assumption the state is asking you to make, that they belonged to other individuals, and you have no evidence of that. Then we heard from Cassie, Richard's ex-girlfriend, his co-defendant. She was very forthcoming. She is a lifelong drug user. She admitted responsibility for some of these drugs. And you heard her say that she was upset that Richard didn't do his part. She's mad that he didn't lay down as the fall guy so her deal could go through smoothly. She cut a deal with the state that if she goes forward with her testimony, they will not object to her being released early. Her freedom is on the line here. Please take that into consideration when you review her testimony. Is that a credible witness to you? And she was even evasive with me when I asked about if she could be getting early release. The only testimony that you heard about some of these items being traded potentially for guns or drugs was from Cassie, and she didn't give you a single specific instance. She made sweeping generalizations so that she could successfully do what she needs to do for the state without making anything up. And does that make Richard and Cassie an enterprise? Even if you believe that he has possession, even if you believe that he's trafficked, what was presented as an alleged sale to one individual? I implore you to look at the definition of enterprise as Judge has read it to you and as you will read it in your instructions. There's no legal partnership, there's no legal entity, there's no group, there's no organization. And where is the pattern? Again, Cassie didn't give you a single specific instance. Finally, Investigator Sanders testified about his involvement with the CI. He testified that people can be paid for their work or they can work off charges. And that's a huge incentive to create other suspects, because you're not valuable and you can't do those things to help yourself unless you can give someone else up. Again, he testified that there was clear audio, clear video that you haven't seen, that you haven't heard, and the CI is not here. Ask yourself why. You've heard testimony and admissions that there were multiple people present. You saw how large that property was. 2 men left on motorcycles. You know other people were there. But that wasn't presented because it doesn't fit the narrative. Investigator Sanders also testified that they didn't find receipts for any of these items. And I mean, do you keep receipts for everything that you buy? Do you even get receipts for everything that you buy anymore? Again, this is a lack of evidence. Hold the state to their burden. Does your common sense tell you that there could be another reasonable explanation? Then you have doubt. Things do not add up here. There are holes. There are too many other reasonable alternatives for this situation, and you don't have to abandon your common sense to get there. So what are you really left with? Law enforcement trying to circle the ranks to close an investigation, and a co-defendant with a vested interest in testifying against Richard. Her freedom is at stake. If she doesn't cooperate, the state will oppose her motion for early release. The narrative here, trying to paint this as an enterprise, that's something you have to find in order to find Richard guilty of engaging in corrupt activity. There's no evidence to suggest that it is. Even if you believe Cassie's testimony, there is no enterprise here. You're left with a large amount of property, items, and land that the state wants you to forfeit to the government. And judge has instructed you that this must be derived from directly or indirectly or realized through conduct in violation of the first count. The first count is engaging in corrupt activity. There is no enterprise. There's no evidence that Richard stole anything, no specific evidence to any of those items being submitted because the evidence doesn't exist. And the judge has instructed you regarding forfeiture. Specifically, it is the quality of the evidence that must be weighed beyond a reasonable doubt. I submit to you that you should have doubts. It's entirely reasonable for you to have doubts. And as a result, you should find Mr. Johnson not guilty. Thank you.
All right, Ms. Collins, we have the stage.
I'm going to address a few things quickly and then move on. I agree with the defense that Johnson was not on the video buying drugs. I absolutely agree with that. He was on the video selling drugs, not buying drugs. And you actually will have the pictures from that drug buy on July the 5th, 2022. Look at States Exhibits 35 through 39. Those are clear shots of this defendant standing right in front of the place where the methamphetamine was found 7 days later during the drug buy. So no, he wasn't on the video buying drugs. He's on the video selling drugs. And why isn't the CI here, and why didn't you see the video? He's not charged with those two counts. He's not charged with the two drug buys from June 6th and July the 5th, or I'm sorry, June 9th and July the 5th. That was what we used as probable cause to get a search warrant to go into his house. And that's what shows the pattern of corrupt activity. That's what shows the intent of possessing all this meth. This is what he does. He sells drugs. You didn't see it because he's not charged with those two crimes. Talked about these two people that left on the dirt bikes at the in the drone footage. You can see them scooting out on dirt bikes when the law enforcement arrived. Well, they're not here, they're not presented to you because they weren't 9 feet from 215 grams of meth. There was only one person that was 9 feet from 215 grams of meth, and he's sitting right there. It's just smoke and mirrors. It's a stretch, hoping that you'll grasp at one of those straws, and don't fall for that. Now, I'm sure that during the trial there were lots of things mentioned that were developed and they left questions in your mind, but be mindful of the judge's instructions. There are often legal reasons for what we are allowed and are not allowed to share, and as the judge has instructed you, the evidence and testimony that can be considered in this case is what you heard from that witness chair and the exhibits that are on that table. That is what you can consider as evidence in the case. It's important to remember that nothing that the defense attorney said in her questions is evidence. So when she asked leading questions and she asked the question hoping the answer is in the question, that's not evidence. The answer is the evidence. Now, one of your main jobs as a jury is to weigh the credibility of the witnesses, and to do this, you apply the test for truthfulness that you apply in your everyday lives. You look at the witness's appearance on the stand, their manner of testifying, the reasonableness of their testimony, their opportunity to see, hear, and know the things they are testifying about. Who is there? Look at the accuracy of their memory, their frankness, their lack of frankness, their intelligence, their interest and bias, taken with all the facts and circumstances, with all the evidence that's been presented. And with all of that in mind, you decide who to believe. And let's apply this to the witnesses that you heard from. The BCI chemist. She's an expert, and her job is to weigh and test substances. That's it. She comes here, she provides a report, she tells you the weight and the substance. The findings are on the reports. They're States Exhibits 1 and 11. She's no interest or bias. She's just a scientist. Next, you heard from the victims of the theft offenses whose property was recovered on the defendant's 5 acres. They have no interest or bias in the case. They're simply explaining that their property was taken, it was stolen, and then it was found. They didn't even know the defendant prior to this. And you didn't hear any evidence about him stealing the property because he's not charged with theft. He's charged with receiving stolen property for possessing property that's stolen. There's a difference. Those are two different crimes. He's charged with possessing property that's stolen. That's what you heard evidence of. So the fact that you didn't hear evidence about him stealing it, it doesn't matter because he's not charged with that. He's charged with receiving it after it was stolen. And he did that. He possessed stolen property. Next, you heard from several law enforcement officers, Sergeant Craig Seaman and Deputy Dylan Quinneville. They simply relayed the events of the things that they were involved in. Sergeant Craig Seaman entered the camper. He took the defendant into custody at the July 12th search warrant and took everything out of his pocket, the gun, the wallet. There's a pile of things in a picture. You'll see those. Put them on the counter, and then Investigator Sanders searched those. Dylan Quinneville was involved in the traffic stop that then led to a search warrant that led to more drugs found in the defendant's white SUV. Next, you heard from Detective Sergeant Vinny Antonor, who relayed his actions and his role in the investigation. And the defense wants you to believe that he was evasive and that he didn't answer the questions. He gave long, drawn-out answers. Well, when you ask a question of a witness, you get the answer. Just because it's not the answer you like or the answer that you want doesn't mean that it's not correct. It just means it didn't suit your question. There's nothing wrong with that. He testified, period. Investigator Chris Bowen, again, relayed the facts and evidence and his overwhelming knowledge of the drug trade in Highland County. All law enforcement officers, none of them have a bias in the case. They don't get paid extra money to win or lose. It's nothing like that. They simply come and they tell you in as easy terms as possible to understand what they saw, what they observed, the evidence they collected, and what they know, period. Next, you heard from Cassie. Now, the defense is hoping that you don't believe anything that she agreed to testify, or that she testified to, because she agreed in order to obtain a more favorable sentence. But it is your job to judge the credibility of the witnesses. She has no bias and prejudice, and today they want you to believe that she was angry, but if you remember the testimony, she said, "I'm not mad at him. I'm angry that he didn't take responsibility for his part in this and that I actually have to testify, but I'm not mad at him." That was the testimony, so that's the evidence that you can consider. She was repeatedly told, and she told you, the number one rule of testifying, to tell the truth. She's taken response. She's an addict that partnered with her drug dealer. She's taken responsibility for actions, and she's relayed the events to you in an open manner. The defense told you in jury voir dire that something important to judge the credibility, and jurors answered, eye contact. Well, remember Cassie as she testified. She sat in the chair, clearly in prison, held her head up, looked at you, looked at the people in the courtroom, didn't look down. She's not trying to hide anything. Open with her testimony. She was forthcoming about her addiction and the fact that she and the defendant bought and sold drugs. The defense told you in her opening that Cassie has a history of drug use. What she doesn't have is a history of drug trafficking. In fact, she admitted that she's been an addict for 12 years and that she was selling with this defendant in order to feed her drug habit. Cassie, was in the best position to see, know, and hear what was going on in this business. She was right there. She was his partner. She told you she's no interest in bias and, again, wished she didn't have to testify. She wished the defendant would have taken responsibility for his actions. Finally, you heard from Investigator Sanders, who has over 40 years of experience, mainly focused on covert drug operations. Again, Investigator Sanders kept detailed notes of his work, collected all the evidence available, and has relayed all of that to you in an open manner. He was in the best position to see and hear what was happening at the various scenes, and he has no interest or bias in the matter. Again, simply doing his job. Now look at the elements of the crimes alleged and the evidence and testimony that proves each of these crimes. And there's really no question that these crimes occurred in Highland County. Everybody has agreed that Joey's Pizza, the traffic stop in September was in Highland County, the Butters Road property is in Highland County, all of this occurred in Highland County. So there's really no question about that. I'm going to address the charges in a different order than they are in the indictment. I'm going to start with counts 2 and 3 first, which is the aggravated trafficking in meth and aggravated possession of methamphetamine. And the aggravated trafficking charge is what we talked about in jury voir dire, what we all commonly call possession with the intent to distribute. Counts 2 and 3 are related to the large bag of methamphetamine located in the fire truck canister. This is State's Exhibits 98 and 99 and 100, and State's Exhibit 2, this bag of meth. That bag alone weighs over 167 grams. Counts 2 and 3 also relates to State's Exhibits 3, 5, and 6. These bags of meth. When you add the weight of all of these bags of meth together, the total is just shy of 214 grams of meth. It's 213 point something. Just shy of 214 grams of meth. The typical dose of methamphetamine, per Investigator Sanders, for personal use, one dose is about 1/10 of a gram. So this is far more than personal use. This is intended for resale. Bulk amount of meth, and it's in your jury instructions, is 3 grams. And we know that what this defendant intended to do with this methamphetamine. We have well over 50 times bulk amount here. The defendant had previously sold to a CI. That's part of his intent. Cassie told you that the black box in the kitchen cabinet was the defendant's box and that they both sold out of the box. Some of this was recovered from there. She also told you that they had just re-upped the night before. And re-up means that they went and they got more supply from their supplier. The methamphetamine in the fire truck canister was that bag, that 167 grams. That bag had just been purchased the night before, and the intent was to resell it at a profit. Cassie told you that they were paying about $150 an ounce for meth, and they were purchasing for resale once or twice a week. There are just under 8 ounces of meth here. And at $150 an ounce, that means they spent about $1,200 on this meth. And the intention of reselling it at $10 a tenth, about $21,000 street value piled right there. The state has proven each element of counts 2 and 3 beyond a reasonable doubt. Next are counts 4 and 5. Again, the trafficking in drugs is related to possession with the intent to distribute. And these counts refer to the hydroxyphenicidine, which we all commonly call PCP. That's what it was testified to. Even the expert commonly called this PCP. It was located in the camper. Counts 7, 8, 9, 159, 137. And most of this was located in the Sentry safe, and again in that black box from the kitchen that they both sold from. Again, more than personal use, and again, Cassie told you that the defendant's drug of choice was methamphetamine, her drug of choice was fentanyl. He possessed the PCP with the intention of selling it, and the state has proven each element of counts 4 and 5 beyond a reasonable doubt. Next is count 6, possession of cocaine. Again, located in the safe. Again, the defendant owned it. This is his camper. Again, he possessed it. The state has proven each element of count 6 in the camper where the defendant lived. Now, I want to say, because it seems to be believed that in order to possess something, it has to be in your pocket. That's not the law. You possess your car and it's parked around in front of the courthouse. Read the definition of possession in the jury instructions. It doesn't mean that it's in your pocket. Count 7 relates to the stolen truck recovered on the defendant's property. This defendant possessed a stolen motor vehicle when he knew or should have known that it was stolen. Now, clearly this truck is a motor vehicle. There's really no question about that. And clearly it was stolen. Billy Bird came in and he sat down and he said that he reported it stolen, and when law enforcement found it, they ran the plates, it came back as stolen. Billy Bird came, he identified his truck with one noticeable difference. His stolen truck was black, and this one now was green. Now, the defendant knew or should have known it was stolen. They painted it green right in front of his house, right where he's remodeling, and you have the evidence of that. State's Exhibits 183, 184, 185. Look at these pictures closely. You can see the green overspray where it was painted. Again, green areas where it was painted. Investigator Bowen noticed this when they were out there and took pictures because that's the evidence that you need. And in this picture, right here, what is this? A can of green paint. Compare this to the pickup truck. It's the same color. And where is this located? This is the mobile home he's remodeling. Why paint a truck if you aren't trying to hide its identity? The defendant knew very well the truck was stolen, and he's guilty of receiving stolen property. Remember, we don't have to prove that he's the one that stole it. We have to prove that he possessed it. And right there it is, sitting on his property. It does not matter that he didn't steal it. He's not charged with that. He's charged with possessing it. And this is the circumstantial evidence that we spoke about in jury voir dire. It's no different than waking up to snow on the ground. You can find that he is guilty based on this kind of evidence. And your instructions say, in the absence of direct evidence of a defendant's guilt, circumstantial evidence by itself can justify a finding of guilty if the circumstances are entirely consistent with his guilt and entirely inconsistent with the theory that he is not guilty, and so convincing as to exclude reasonable doubt of guilt. It is wholly inconsistent, and it flies in the face of common sense, that this defendant didn't realize the truck was stolen when it was painted a different color. The state has proven each element of count 8, and remember on your verdict forms to circle that this is a motor vehicle. It obviously is. It's a pickup truck, a motor vehicle. Now, count 9 is a stolen chainsaw belonging to Robert Guyton. Again, no question the chainsaw was stolen. Robert reported it stolen. When it was recovered, they ran the serial number, and it was stolen, along with several other chainsaws on the defendant's property, and you'll see pictures of those all hanging in a row in the house that he's remodeling. Again, the defendant didn't buy the chainsaw at the store. He either stole it himself, or more likely, he traded it for drugs. Either way, it doesn't matter if he stole it or if he traded it. It was stolen and he possessed it. We don't have to prove who stole it. That's not what the law says. Did he possess stolen property? Yes, he did. It's right there in the house he's remodeling on his land. Next are counts 9, 10, and 11, possession of methamphetamine, cocaine, and a fentanyl-related compound. Again, these are the drugs located in the defendant's vehicle on September 6th of 22. When the defendant and Cassie were planning to pick up their belongings and make a run for it, there's no question the defendant was driving the vehicle and that he owned the vehicle, and those drugs were found in the vehicle he controlled. He possessed those items. 2 or more people may possess an item if they both can control it. Both Cassie and the defendant could control these drugs. They were in the front seat of the vehicle the defendant was driving. Remember the bank robber scenario we talked about in jury voir dire and the example of the getaway driver? Bank robber 1 goes into the bank, he shoots the teller. Bank robber 2, getaway driver, now he's just sitting in the car, but as soon as bank robber 1 shoots that teller, bank robber 2 is responsible for that murder because they're working together. This is the defendant and Cassie Brigner in this case. Now, the defense wants you to believe that because he wasn't right next to the drugs, well, they're not his. But the testimony from investigator Sanders was the defendant was about 9 feet from about $21,000 worth of dope. The largest quantity of drugs was found in the kitchen. And you'll have the picture that shows the couch in the kitchen. We talked about it yesterday. It's no distance. It's a camper. It's a small area. Next, let's go back and look at count 1, engaging in a pattern of corrupt activity. Engaging in a pattern of corrupt activity, it's like a fishnet. It traps everything that comes into contact with it. To prove this, the defendant did, while employed by or associated with an enterprise, conduct or participate in, directly or indirectly, the affairs of an enterprise through a pattern of corrupt activity. So first, the association. An enterprise includes an association of persons that includes unlawful enterprises. 2 associated people are Cassie and the defendant. There's no question. These 2 participated by performing activities necessary or helpful to the enterprise. And the enterprise here, it's drug dealing. Corrupt activity by law, and it's in your instructions, includes trafficking in meth and possession of meth. Next, you have to determine if the total proceeds exceeds $1,000, and you are allowed to look at the value of what they possessed. It's not difficult. 1 bag of meth alone, State's Exhibit 2, Investigator Sanders testified, has a street value of over $16,000. State's Exhibit 2 alone. So that's this bag. It's not including the other drugs in the house or the stolen vehicle. Just 1 bag alone gets us there. You not only have Cassie's testimony that this is what they did, they purchased large quantities of drugs and resold them. You also have pages and pages and pages from ledger books showing the various customers who purchased drugs and other associates like John and Tara, who put money in together with Cassie and the defendant so they could make the trip to Cincinnati, or make the trip to the city and purchase a quantity. It was like $3,500, I think, and they were going to come back and divide it up. You have those pages. It does show a pattern of corrupt activity. Investigator Sanders testified that he knew about 8 or 10 people in those books just from working drugs in Highland County. You also know from the testimony that there was a lot of traffic in and out of the property. And that's something you know from the testimony is very common for drug trafficking houses. Engaging in a pattern of corrupt activity is a fishnet, and it gets fuller and fuller, and it encompasses everything that it comes into contact with. This is Johnson's business, and it's Cassie's business, and business is good. So good that at Johnson's camper and in his SUV, law enforcement finds multiple books of other known drug users with numbers besides their names. You have the quantities of drugs that are being sold and fronted. You have the amount of money. A number there's a lot of evidence of this trafficking there. They find multiple sets of scales commonly used to weigh meth. Investigator Sanders said in his over 40 years of experience, this was a lot of different sets of scales, which uncommonly a lot. They found substances that didn't test positive as anything. It was brought out yesterday, like a bag of no controlled substance found. Again, easily explained by Investigator Sanders. He's seen this before, lots. It's called cut. It's kind of the drug street name for something, and basically it's, like was explained yesterday, adding baking soda to cocaine. You've doubled how much you have to sell, but you've cut the quality. It's considered the same, and of course they have cut at their house because they're doubling what they're trying to sell in order to profit more. They found multiple cell phones, baggies, guns, tools, and he owns the Butters Road property. And yet Johnson hasn't filed a tax return for at least the past 3 years. There is an association. There is trafficking and possession of meth. There is trafficking and possession of PCP. There is stolen property, and the value is easily over $1,000. The state has proven each element of engaging in a pattern of corrupt activity beyond a reasonable doubt. Ladies and gentlemen, when you look at all the evidence and look at everything these 2 are doing, it's easy to come to that conclusion. Finally, the forfeiture specification. Now, a good portion of this property was seized and removed because it is suspected to be stolen. Now, the defense would ask you to believe that it's not stolen because the owner hasn't been found. Well, that's not the evidence. The evidence is that Detective Antinor said these types of things are often stolen and traded for drugs. Investigator Sanders told you the same thing. Detective Antinor said these types of items are reported stolen daily. The problem comes with the owner not having a serial number for these items, and then it's hard to prove who owns what. He noted that these things that could be identified as stolen have already been returned to their rightful owners, and that they are still working to locate the owners of the other property. Cassie also told you that the defendant often traded things for drugs. So even if they aren't stolen, this defendant gained these items through his illegal drug activity, and therefore those items are subject to forfeiture. There are no receipts, no warranties, no titles, and while we may not have receipts for everything, as the defense said, when you look through this list, some of these things should have a title to them. Enclosed trailers, a lawnmower, things like that. There should be some proof of ownership. They've searched through everything in this defendant's possessions. There is nothing that shows that. The money throughout the house, some of it's rubber banded together, stashed in different places, subject to forfeiture, because again, the testimony is that this defendant made his money selling drugs. There's no evidence presented of any other income. The guns he accumulated, again, subject to forfeiture. He not only traded guns regularly for drugs, according to Cassie, but he used the guns to defend his drug trade. Investigator Sanders told you, this is a dangerous business. And when you look at the pictures, look at State's Exhibit 102 and 113. The gun is literally under the potato chip bag in the same cabinet that Investigator Sanders is pulling the black box from that Cassie said they regularly sold dope out of. It's right in the kitchen cabinet. And you can see the gun under the potato chip bag. Finally, even if his property, which he bought from Roger Castle, and the evidence was that he's a person previously convicted in a drug trafficking ring, was used to store his drugs. This property was used to store his drugs and sell his drugs from. It is more probable than not that this property was gained and used by the enterprise for the drug trade. Again, the state's not required to prove motive, but the motive for this business is obvious. It's money. This is all about money. Accumulating assets, money, property, tools, vehicles, guns. Accumulating all of that without hitting a lick. It doesn't work. And think about this. Why would the defendant and Cassie be planning to hit the road the day the indictments were coming in if they weren't guilty? And the defendant actually thought he could pay some other person in order to keep from being indicted. Again, no reason to do this if you're not guilty. Now, the state must prove each and every element of the crimes charged beyond a reasonable doubt. And the defense asks you to expand reasonable doubt to be some burden that's completely overwhelming and never be achieved. They want it to be impossible. It just isn't that. If reasonable doubt were, as the defense says, no one would ever be guilty of a crime ever. The legal standard of reasonable doubt is doubt based on reason and common sense. And as the instructions say, you can equate this to your own lives and the decisions that you make in your own lives. Let's talk about buying a car. You shop around, you collect the evidence. You want a red SUV, and you find one, and the odometer says 50,000 miles. And the payments will be about $350 a month. Now, your budget allows for a payment of $400 a month. It's everything that you want in a vehicle. And all the evidence points to you buying the car, and you decide this is the car to buy. Now, there is some remote possible doubt that this is not the perfect SUV for you, but reasonable doubt, doubt based on reason and common sense, that's been overcome. And of course, you buy the car. It's not your job to look for reasonable doubt. If it were present, it would have presented itself from the evidence, and it just didn't. It doesn't exist. In this case, reasonable doubt, doubt based on reason and common sense has been overcome, and the state has proven each element of each element of each crime beyond a reasonable doubt. Ladies and gentlemen, the state has proven each element of each crime in this case, and I am asking that you now pull up this net. Review the evidence, remember the testimony, using your common sense and judgment, come to the only logical conclusion that makes sense here. Find the defendant guilty of these charges. Thank you.
All right, ladies and gentlemen, you heard the closing arguments against bringing those, which, as I advised you before, are not evidence. So if your recollection of the evidence is different from what one of the attorneys has said, you can't consider what they said because that's not evidence. Now, I will instruct you on how to conduct your deliberations and prepare your verdict once you've reached them. You must be uninfluenced by any consideration of any sympathy or prejudice. It's your duty to carefully weigh all of the evidence, decide all disputed questions of fact, apply the instructions of the court to your findings, and to render your verdict accordingly. You must be uninfluenced by any consideration of passion or prejudice. It is your duty to carefully weigh all of the evidence, decide all the disputed questions of fact, to apply the instructions of the court to your findings, and render your verdicts accordingly. Fulfilling your duties, your efforts must be to arrive at a just verdict. Consider all of the evidence and use your common sense and make your findings with intelligence and impartiality, without any bias, sympathy, or prejudice, so that the state and defendants will feel that their case was fairly and impartially tried. Now, if during the course of the trial, the court has done anything which you consider an indication, in my view, of the facts of the case in general, you're instructed to disregard that. Of course, my rulings are not based upon what I believe or any position favoring one part or the other. You know, it's based upon the rules of the law as I interpret them. And the courts aren't to interfere in any way with a jury's decision. Now, your initial conduct upon commencing deliberations is a matter of great importance. It's not wise to immediately express a determination or insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position even if you later decide it may be or you are wrong. Consult with one another, considering each other's views, deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgment. You must each decide the case for yourself, and you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you find that it is wrong. Thank you. However, you should not surrender an honest conviction in order to be congenial or to render a verdict solely because of the opinions of the other jurors. You may not discuss or consider the subject of punishment. In the event you find the defendant guilty, the duty to determine the punishment is placed upon by law upon the court. When you go to the jury room, your first function will be to select one of your number as foreperson, and that person you select will preside over your deliberations, but does not have any greater power, nor does that person's vote have any greater importance than anyone else's. Foreperson will provide or serves the purpose of helping you to conduct your deliberation in an orderly manner and give each juror an opportunity to express your opinion. Let's see here. There we go. The court will place in your possession the exhibits, with the exception of those that contain controlled substances. We'll retain those, and I believe the USB that has the video will also be retained, because if you want to see that, you'll have to ask the court to bring you back in to look at it. Because we don't want to, well, number one, we can't give you a device to record them or to play them in the jury room. And secondly, the actual controlled substances want to make sure that there's no safety issues. Now, until your verdict is announced in open court, you're not to disclose to anyone the status of your deliberations or the nature of your verdicts. Now, this being a criminal case, before it can be said that you've reached a verdict, it's necessary for all 12, I'll repeat, all 12 of the jurors to agree upon a verdict, and that's as to each count. You'll have with you in the jury room, in addition to the exhibits that the court submitted, and a copy of these instructions, separate verdict forms for each count. Now, the verdict forms for the first 11 counts, each of them will have the name of the case number, and the charge. And then they will read that we, the jury, having been duly impaneled and sworn, find the defendant, Richard Wayne Johnson, and then those are blank space. And then you will write in that blank space either guilty or not guilty, according to your finding as to that particular count. And then it goes on to say what the charge is. And there's 12 signature lines. And after you reach the verdict, all 12 of you have to sign your name and date. And your signature is your indication that you concur in that verdict, and it is your verdict. If you don't have all 12 of you signing it, then you don't have a verdict. Now, as to counts 2, 3, and 7 of the indictment, there is an additional finding on the verdict forms that must be made if and only if you find the defendant guilty of the charge in that particular case, or in that particular count, I should say. For counts 2 and 3, you'll make a finding as to the amount of the controlled substance in that count. And for count 7, you'll make a finding as to whether the property involved was a motor vehicle, and you'll indicate your finding by circling the finding that reflects your finding or striking out that does not. And so I'll read the additional finding for you on count 2, 3. There are 4, if you remember the jury instructions. Again, you'll have those with you if you need them further. And in that count 2, 3, it does read, additional finding if verdict is guilty. Again, if it's not guilty, you don't have to make this determination. But if and only if there's a verdict of guilty, you will then, the verdict additional finding reads, we further find the amount of methamphetamine involved was 1, less than bulk amount, or 2, equal to or exceeding bulk amount but less than 5 times bulk amount, or 3, equal to or exceeding 5 times bulk amount but less than 50 times bulk amount, or 4, equal to or exceeding 50 times bulk amount but less than 100 times bulk amount. And then I've put there in the parentheses, circle only one finding, so that that'll be clear. So in this one, you won't strike out everything, just circle it. And then in count 7, that's the one with receiving stolen property, alleging that it was a motor vehicle, and that says additional finding if verdict is guilty, and again, only if verdict is guilty. We further find and specify the property involved, and it says was or was not a motor vehicle is defined in ORC 450101. In that case, either circle or strike through, circle what reflects your finding, or strike through what does not, so that it would then the wording would read what your finding is. And those will be sent to you along with the substantive instructions. Now, you will be deliberating in the jury room, and I didn't mention this to you earlier, but you're not permitted to have any electronic devices with you while you're in the jury room. So if you have a phone, the bailiff will collect those in a bag and then return them to you if you break for lunch or at the end of the deliberations. If you need any communication with anybody outside, you can give a note to the bailiff and he can call for you if that's necessary. Bailiffs will be stationed outside the door to ensure your deliberations are not interrupted, and it'll be your sole means of communication with the court. Now, bailiffs cannot answer any questions about the case or the evidence. If you have a question or if you have a request for something, write it down, knock on the door, and give it to the bailiff. The bailiff will then give it to me, and then after our consultation with the attorneys, I'll determine the response and return it to you in writing. Now, one of the things I'll tell you is sometimes it'll happen is I've received questions saying, well, what happened before this, or who did this? You're asking me to tell you what evidence is. I can't do that because the evidence is already in. You can only decide the case based on what the testimony was and the exhibits. And so if you have a question about a piece of evidence or about a fact that's not in evidence, I can't answer that. I'm not permitted to give you additional evidence about the case. So if you ask for that, I'll respond in that way in writing. If you ask a question about the law, and again, this is it's a fairly complex case, what I'll probably do is write back, refer to page, whatever, because all the questions about the law should be in these instructions. But again, I know they're complicated, and so if there is a question, if you ask that, write it down, and then I'll respond in writing, probably directing you to those specific pages that answer your question. All right. Now, until you've reached a verdict, you're not to tell anyone what the status of your deliberations are. When you do reach a verdict, knock on the door, inform the bailiff, and then after we reassemble everyone, you'll be returned with to the courtroom with the verdicts. Now, I want to thank you, ladies and gentlemen, for your patience, your cooperation, and your attendance during this trial. You've been very attentive, as I've noticed, and we've attempted not to waste your time. I think that attorneys did a good job in presenting the case in an expeditious and efficient manner, although the important thing was they were each given the right to present anything that they wished to in this matter. All right. Now, is there anything else from counsel?
Your Honor, may we approach?
You may. Okay. I normally don't print on both sides. I did that to cut down on the number of pages on the instruction. And in doing so, I confused myself. And I forgot to give you the instruction on the specification. Or, I'm sorry, the verdict form on the specification. I did give you the instructions. On the verdict form on count 12. Now that's going to be a little more complicated. There are 54 items. I didn't want you to have to sign your name 54 times, so I came up with a way that will allow you to sign your name just once for all 54 items, but it will require making a finding and writing it as to each item. So what the verdict form says for count 12 is that we, the jury, having been duly impaneled and sworn, find that the following items listed in count 12 are or are not subject to forfeiture as shown on the written finding inserted next to each item due to its being used in, intended for use in, derived from, directly or indirectly, or realized through conduct in violation of count 1, of which we have found the defendant guilty. Then immediately below that are an instruction in parentheses that reads, insert the word "are" next to the items that you find are subject to forfeiture. Insert the words "are not" next to the items you find are not subject to forfeiture. So then those 54 items are listed. And so as you see here, go down the list, you put "are" or "are not." I know that's extra work, but it's, I think, better than having all 12 of you sign your name 54 times. I'm not even sure what the math on that is. I think it's over 600 signatures, so that way we won't have that. Okay. Now, we're going to have you go to the jury room here in just a moment, and then I'm going to go over the final instructions just to make sure that there's no other typos or corrections that need to be made. I will tell you that these instructions, I keep them in a computer instead of writing them each time, and I convert, a previous case over. And the previous case that I used had multiple defendants, so sometimes there was a plural. So if you find that I didn't catch that, that's only one defendant in the case. So just disregard that. All right, now, for the alternates, you've sat through a day and a plus of proceedings, and we appreciate that. You've been on insurance policy. But since nothing's happened to any of the first 12, you will not be participating in the verdict, deliberations, and verdict. However, and I'm going to release you you can go and go back to work or go to your home as long as you stay within 20 minutes of the courthouse. And the reason for that is this. In the event that during deliberation something happens that one of the 12 jurors have to be excused, then we will call. You be first, Ms. Rusa, and Mr. Sipple will be second. And so, because of that, the instructions that I gave you are still in effect. You must follow those. And that is not to discuss the case with anyone, not to form any opinions about it, not to permit anyone to discuss it with you, not to discuss anything with any of the attorneys or people who have been involved witnesses, not to obtain any information about the matter on your own, and not not to read or listen to anything about it in any form of media, on the internet, radio, TV, social media, etc. We'll also ask you to give your cell phone or the phone number to the bailiff so he can contact you as soon as we do have a verdict. Once we do have a verdict, then you'll be released from that obligation and you will be free to do any of those things if you want to. You don't have to speak with anyone, but if you want to, you can. But until you've been informed there's a verdict, you cannot do that. And so with that, I'll excuse the two of you if you would come over here and give your number to the bailiff. Then the bailiff will collect the verdict forms, the cell phones from the jurors as you go back to the jury room. And then as soon as I make the final edit on the jury instructions, we'll send those back to you. The exhibits will also be provided to you, like I said, except for the actual, the ones that contain the controlled substance. And we also would prefer that you not open any of the bags, again, just for safety purposes. So, that any of the items are in. If you need to, you think you need to, send out a request for that, and then we'll have that, we'll done that in a manner that will make sure everybody's safe. All right. With that, we'll submit the case to you. If you would just lay your cell phones on the ledge there, and the bailiff will collect those from you, and go ahead and retire to the jury room, and bring back in the evidence and the other items you'll need. Thank you.
Please rise.
Okay, we did have a conference. Ms. Collins indicated that they had noticed some typos or mistakes, and I believe I noticed most of them, if not all of them, but had made the change. But if you want to go ahead and tell me the ones that you've noted, Ms. Collins, and I'll give Ms. Memsick the same opportunity.
It's Mr. King, Your Honor.
Okay, Your Honor, just a couple. Starting at the bottom of page 8, the last 3 words, it says each of the defendants.
I changed that, I believe.
Page 10.
Let me check just to make sure. Let's see, what was that under?
It was at the bottom of page 8, the last 3 words, it says each
Yeah,
of
okay,
the
I changed
defendants.
that. I changed that to the defendant. Mm-hmm.
Page 10, under law count 2, says the law under which the defendant is charged in count 2 is entitled trafficking.
I read it
should
as
say
aggravated. Yeah. In fact, I noticed that when I read it and looked at the indictment to make sure.
Page 11, essential elements, number 3, methamphetamine, a Schedule 2 controlled substance.
Right, got that? And I read it that way.
Page 13, under reasonable cause to believe, looking at the first sentence there, intended to sell or resell, it says heroin, it should say methamphetamine.
Page 13.
Yes, under reasonable.
Oh, okay, I did not catch that. Methamphetamine, okay.
Page 15.
Wait a minute, let me mark that, because I'm going to just print those pages out. All right.
The first full paragraph on page 15, there's the date is wrong. It says on or about January 12th of 22. It should say July 12th of 22.
Okay.
Page 19, under essential elements, number 3, it says Schedule 1 controlled substance. It should say Schedule 2 controlled substance.
Yeah, I did do the instructions in the definition, but I didn't catch it there.
Page 22, under additional finding, the verdict is guilty. The drug reference is methamphetamine, it should be hydroxy.
We're at?
Page 22, under where the paragraph additional finding, if verdict is guilty.
That's struck.
That shouldn't be there at all.
That will be removed.
I'm sorry, what?
Page 22.
Which section is it under?
The additional finding if verdict is guilty.
On count 4? Oh, okay.
It
Yeah,
does
I
count
accidentally
4.
struck that out, didn't I?
Yeah.
Yes, Your Honor.
Okay. I didn't instruct him on it, but,
Moving to page 23, first full paragraph, right above essential elements. The date's incorrect, but I think you caught that when you were reading it.
it's been changed, yeah.
Page 26, at the very bottom, underneath essential elements, it says the essential elements of the crime of aggravated possession of methamphetamine. It should be possession of cocaine. That's count 6 again.
Yeah, okay.
And the last one is page 46, just again a reference, and this is the second paragraph on page 46.
Wait, let me catch up here. So I'm not used to doing these on both sides. I did it to try to cut down a paper. Already killed enough trees this week. All right, which page?
Page 46, second paragraph, second sentence. It says if you find either defendant guilty.
Okay, is that under verdict form?
It's above verdict forms. It's at the top of the page. It's the second paragraph, second sentence.
Okay, I think when my reformatting, I changed that. What's the sentence read?
Sentence reads, in the event that you find either defendant guilty.
All right.
That starts with, you may not discuss or consider the subject of
Of
punishment.
I did catch that when I read it. I knew I had to change that, and that's on. Okay, the changes I made changed the page number. So let's see.
It may be on 45 at the bottom.
No, 45 is a deliberation.
If you find where it says the heading verdict forms and then go up 1, 2,
Right.
3, 4 paragraphs above that.
4 paragraphs?
Yes.
All right, 1, 2, 3, 4. Oh, okay, there we go. Yeah, I did not read that. I knew I had to fix that, and I couldn't figure out where it was because the reformatting's changed it. All right, great.
Just one thing. Your Honor,
Yes.
I just would also like to verify that for count 5, the additional finding has been struck.
Yeah,
Okay.
I believe it has. I didn't read it. Let's see. Make sure.
It was around page 25 or 26.
25. Yeah, it's been stricken.
Thank you.
All right. And, well, unfortunately, since there's several of them, I'm just going to reprint this all over again. All right. Yeah.
May we give the jury the list of the exhibits? We computed the volume with the number of pictures.
That list is wrong.
Yeah, no, it can't be because it's got incorrect information on it. I noticed that during the trial.
Okay.
Yeah, so no, we won't be able to give that.
That's
to you.
art, like,
Yeah.
I thought some of it was, but
yeah, no.
at least it would point out where the picture's at.
All right. Well, then we'll go ahead and go off the record, and I'll make these changes, and counsel, you can go